Members, the next bill on the calendar is House File 4554, authored by me. I will move that House File 4554 be recommended to be re-referred to the Ways and Means Committee. Members, we thought last week that we would be done, but in the intervening time, the Senate did pass a omnibus bill, I think on Wednesday. And so we have compiled in this bill a number of the provisions that had already gone to Ways and Means and that have been considered and voted on already. In addition, there were other items from other committees that we added into this, plus components that had been requested for changes from the agencies. So we're starting with the original bill is the governor's supplemental budget bill. That's House File 4554. That bill is out of date with the COVID crisis. So we have a DE1 amendment, and I would like to move the DE1 amendment to get the bill in the shape so we can consider it. Is there any discussion? The clerk will take the roll.
Hanson.
Aye.
Claflin. Was that an aye?
Aye.
Claflin votes aye. Fabian.
Aye.
Backer.
Backer, aye.
Backer, aye. Becker Finn.
Aye.
Eklund.
Aye.
Fisher.
Aye.
Green.
No.
Heinzman.
No.
Lee.
Lee, aye.
Lee, aye. Lewick.
Lewick, aye.
Lewick, aye. Morrison.
Aye.
Nelson.
Aye.
Purcell.
Purcell, aye.
Purcell, aye. Sandell.
Aye.
Sundin.
Aye. Aye.
Tice.
Aye.
Wagenius.
Aye.
16 ayes, 2 nays.
The DE1 amendment is adopted. For the bill as amended, this is the Environment Natural Resources Supplemental and Policy Bill. I would like to call on Mr. Hagemeyer and Ms. Taylor to walk through the items in the bill that weren't previously heard in committee recently. Now, Ms. Taylor and Mr. Hagemeyer, who would like to go first?
Mr. Chair, Mr. Hagermeyer and I spoke, and since there aren't a lot of appropriations, I'm just going to quickly go through the Article 1 and we're going to skip the spreadsheet presentation if that's all right.
Yes.
Okay, so starting at Article 1 of the DE1 amendment, the first section is on the PCA providing appropriations. The first subdivision is from the chair's previously heard a dry cleaner bill. Subdivision 2 is from a previously heard bill providing money for the water quality standards for PFAS. Subdivision 3 is the small business loans for the TCE program that we just heard. And then section 2 is the DNR appropriations. Subdivision 1 is a version of the CRP state incentive payments that we heard previously. The funding amount source has changed to the critical habitat private sector matching account, which is why it's under DNR as a transfer to Bowser. And you also notice that the amount has been increased. And then subdivision 2 is an extension that was added to the policy bill previously. The other extension that had been added was moved to the LCCMR bill. And but that was the only other change to the LCCMR bill from what we passed previously. So I'm not going to go through the LCCMR bill when we get there. The next one is section 3. This is an extension of an appropriation from the Outdoor Heritage Fund to the Board of Water and Soil Resources for the Rim Wetlands Partnership. This is an extension that they had requested. And then section 4 is a new section providing $350,000 from the lottery and lieu revenues for the zoos, and this would go to the Minnesota Zoo. Section 5 is a section from an Eklund bill that was extending some previous appropriations for ATV trails. And then section 6 is from the dry cleaner bill that we heard previously. And then on page 5, section 7, it does two different things. First, if you go to page 7, you'll see that it removes a previous appropriation from the cross-country ski account. This is from an Eklund bill. And then on page 11, you'll see another extension of an ATV trail appropriation. And then that concludes Article 1, and then I'm going to go to Article 2. And as the chair had mentioned, we're not going to point out what we previously passed. And Article 2 has a lot of the stuff that was passed as part of the DNR policy bill last week, and I'm just going to point out the new sections. And the first one is section 1 on page 12. This is a provision from the governor's budget. It would establish a soil and water conservation fund. And then the next section I like to talk about would be on page 22. And that's section 18. This is another section from the governor's budget. It would allow the DNR to convey conservation easements on state-owned lands. Then the next section I like to talk about is on page 24. Section 25 was actually in the DNR policy bill that we just passed, but DNR did request a change to this language, and you'll see that on line 24.31. There's some additional language allowing the state park reservation fee revenue to be used for campground operations. The next section is on page 25, section 28. This is another item from the governor's budget bill. This would provide free annual state park permits to any member of a federally recognized Minnesota tribe. And the next section would be on page 26, section 30. This is another section from a Representative Eklund bill on the cross-country ski account. This modifies how the fund can be used to allow the funds to be used for developing and maintaining state cross-country ski trails without it being required to be appropriated by law, as you'll see in the language being stricken. The next section is on page 27, section 32. This is also from the governor's budget bill. It allows the DNR to grant leases on states, like certain state-owned lands, for conservation easement planning purposes. And then we'll skip ahead to page 33. On the bottom of that, there's a section 48. This is new language growing out of House File 749 from last year on the turtle seller's license. This provision would restrict turtle sellers from taking turtles in the 7-county metropolitan area under those licenses. Then the next section would be section on page 36, section 55. This would reestablish the Advisory Council on Water Supply Systems and Wastewater Treatment Facilities. This language was in the governor's budget as well as a number of different bills. The language in here is actually taken from House File 3928. This would previously existed, it had just expired, and this would just reinstate it. And then the next sections 56 through 60 are from the PCA's policy bill carried by Representative Purcell. It modifies some provisions governing the state cleanup of solid waste facilities. Then we can skip ahead to page 41. Section 61 is the TCE ban that we just heard previously. It's very similar to the language that was just passed out of committee. And then we're going to go to page 45. Section 64, this is from a Representative Claflin bill. This is the bill that would prohibit selling personal care disposable products labeled as flushable unless they meet certain industry standards. And the next section is on page 46. This is the perk ban from the dry cleaner bill that passed previously. And the next section on page 48, section 68, this is from a Representative Purcell bill. This would require the DNR to establish a safety program for watercraft operators, and it sets their requirements for that program, including a special endorsement to operate a watercraft with an enhanced wake technology. The next section is section 69 on page 49. This is a new section. It extends some deadlines related to the peacetime emergency, and that it would extend by 90 days the deadlines for making a land use decision, and then for holding meetings under the drainage law. And then the final section I'd point out would be just in the repealer. The paragraph B on page 50 of section 72 is a repealer from the PCA policy bill, and it just repeals a rule relating to a ranking system used by the PCA. And then, as I mentioned, Article 3 is just the LCCMR bill. The only difference is just moving that extension of the trust fund appropriation into there. And then Article 4 is the state's land bill, and there were no changes from what was passed. And that concludes that.
Any questions for Ms. Taylor? Members, we have a number of testifiers, so I'd like to move to them to make sure we get everybody to have their opportunity. In addition, there are a number of folks who provided written testimony, and that is available on the website, committee website as well. So I believe our first testifier is Doug Carnival with the National Waste and Recycling Association. And if each testifier could state their name for the record, and we have an aggregate of a little over half an hour left. So Mr. Carnival.
Thank you, Mr. Chair. I will be brief. I represent the National Waste and Recycling Association, and we have comments on Section 60 of the Delete Everything Amendment that deals with closed landfills, and particularly a section that talks about real property and interest. I want to preface my remarks by saying we've been working with the PCA for some time to try and see if we can come up with language that might work here. We have yet to come to resolution, but as always, we will continue to work with PCA on that score. As we've read the language, we do have concerns about it. After we've discussed it with the PCA, we have more concerns because we think there's a lack of understanding between what the language says and what it intends to do. So we wanted to bring it to your attention and the attention of the committee. As a result, we respectfully request at this time that you delete the provisions from the bill so that we can continue to PCA and perhaps even have it go through the appropriate stakeholder process like rulemaking or some other alternative rather than simply adopted at this juncture. We have not been very much engaged in this along the way. It's important to note that the two landfill provisions in this amendment do not relate to each other. Section 60 deals with 59 deals with the freeway landfill cleanup situation, and that has nothing to do with our concern here. Section 60 is a separate issue and we think needs to be handled separately. I need to note that in its 2019 policy report, solid waste policy report, the MPCA said that the solid waste program should develop standard language to include in landfill closure documents that require the placement of environmental covenants on the landfill property. That's in their policy report. In prior hearings, the PCA has represented that the environmental covenant language is necessary to allow the PCA to put prospective buyers on notice that a closed facility was used for disposal purposes, and that there might be restrictions on the use of the property to protect the integrity of the cover used for the closed facility. They've also, PCA has also said that the covenants would occur only if there's mutual agreement among the parties. However, the purpose of Article 2, Section 60, as stated by the MPCA, appears to be already addressed under MPCA rules dealing with closure procedures, which provide, quote, the landowner must record a notation on the deed to the property or on some other instrument normally examined during the title search that will in perpetuity notify any potential user of the property or purchaser of the property of any special conditions or limitations for the use on the site as set out in the closure plan and post-closure documents. As a result, we think this legislation is unnecessary because the rules already provide a situation and the ability to proceed forward with this. We will continue to discuss this with the PCA. Perhaps the way to do this is for the C&D Rules Advisory Panel to have a forum, perhaps over the summer, if we can't reach agreement with the PCA between now and the end of the session. There's a memo in your packet with more information on this, and we'd appreciate your consideration of that. Thank you for your time.
Thank you. Members, what I'd like to do is go through all of the testifiers. PCA is next, Greta Gauthier, but I'd like her to address that question later, and for her to provide the PCA testimony now, if that's okay. Ms.
That's
Gauthier.
fine, Mr. Chairman. Thank you, Mr. Chairman. Greta Gauthier, Minnesota Pollution Control Agency. Thank you for the opportunity to testify today on House File 4554 as amended, the Omnibus House Environment Natural Resources Supplemental Budget. Thank you for including in this bill many important provisions that are important to the MPCA. We have testified already on many of these items, and in the interest of time and the logistics of this hearing, I won't repeat all that testimony. I'll just touch briefly on some key priorities of ours, which include the TCE ban compromise language. Of course, that we just discussed that, but it is also in this bill. Also full funding for our PFAS study at the MPCA that is part of the LCCMR bill in Article 3. We are grateful to have that. This is very important information that we need to look at and learn about PFAS and how fast they move into groundwater and how fast they are taken up into crops. Also, our MPCA land policy bill, very grateful that that has been put into this bill as well. It has several key land policy items around Superfund and landfills. Most importantly, this bill has provisions related to priority qualified facility landfills. And we need those provisions in order to continue with our work to clean up at the Freeway landfill in Burnsville. We also appreciate the Advisory Council on Water being included here. That is an important entity that all parties want returned. So those are some of our high priorities. I will say that we know that times being what they are and the economy that our budget items are not represented in the bill. We would like to work with you more on the closed landfill issues to see if we can reach some agreement there. And we also would like to talk more with the chair and others about the dry cleaning provisions in the bill. But I will defer to my fellow Assistant Commissioner Kurt Kudelka to discuss that and answer Mr. Carnival's issues later on. Also wanted to say we appreciate the funding for establishing water quality standards for PFOA and PFOS, and the ban on PFAS and food packaging, the ban on PERC, and the labeling requirement for personal wipes. We have been vocal on that and the problems that personal wipes cause, the problems and costs they cause to municipalities. With that, Mr. Chairman, that concludes my testimony, and thank you. I'm happy to take questions now or later.
Just hold till later. I will go to DNR next, Bob Meyer.
Mr. Chairman, members, thank you. For the record, Bob Meyer, Assistant Commissioner, Department of Natural Resources. And we do appreciate the work that the committee is doing on this bill, House File 4554, which does contain many of the pieces of DNR policy language that we've previously discussed, so I won't go into detail on that. We do have some concerns about some of the language in the bill, specifically dealing with the critical habitat match transfer to Board of Water and Soil Resources for CREP easements, incentive payments. The purpose of these dollars were for permanent conservation, acquiring land, and also in statute, if you read it, let me just pull that up here really quick. It's for the purchase of land or interest in land by the commissioner for permanent protection. What we're doing here now is using this $2 million to subsidize these CREP payments, which typically are 10 or 15-year easements. And in addition, Mr. Chairman, on our website, we educate people. These are voluntary donations from individuals for the license plates that they have out there. And we encourage them that it's being used for habitat, critical habitat protection, wetlands, prairies, things like that, for permanent protection. So I know other people are concerned about it as well. They'll be testifying, but that is one of our major concerns with this piece of legislation. With that, Mr. Chairman, I'll stand for questions. I'll be around later.
Mr. Spreck with the Deer Farmers Association.
Good afternoon, Mr. Chair. Tim Spreck with speaking today for the Minnesota Deer Farmers Association. I'm going to address the DE1 amendment as it was originally drafted with specific interests in Section 15 and 16. In Section 15, immediate notification of any escapes required. Mr. Chair, picture a scenario where a farmer's out working his deer. A storm comes up, a tree comes down, the fence is damaged, and several deer are spooked and they escape. At that time, this farmer is in immediate violation because he has not fulfilled the immediate notification. So what we're doing is we're denying him the ability, him or her, the ability to recapture that deer in the heat of the moment before it's long gone. And we're telling that person, you have to get on the phone and call. And by the time that that is addressed, the deer would no longer be able to be recaptured. So, well, currently in statute, they have up to 24 hours. This has been workable. It's something that the organization is on board with, and we would appreciate some additional consideration in this area. In Section 15(1)(b), this is a big one, Mr. Chair. Hunters have the ability to kill and keep and escape deer. So in this scenario, through no fault of their own, whether it be vandalism, trees falling on a fence, storm damage, et cetera, and a deer would happen to escape, a hunter could immediately shoot and possess that deer. Mr. Chair, I want to draw your attention to the Rinke Noonan letter from attorney Gary Lestico, which addresses the constitutional rights violations that this particular section creates. And we believe this is an unintended consequence, but it does really allow a taking without compensation. And this needs to be something that this committee should also consider. We find this particular area to be specifically discriminatory against deer farmers. And in a scenario where an unscrupulous person would like to shoot a trophy buck without paying for it, and sometimes these can have values in $20,000 to $30,000 range without any trouble. That person could cut the lock, and this could be done at twilight, early in the morning when it's dark. Cut the lock, open the gate, allow a deer to escape, and immediately shoot it. And at that point, there's really no legal recourse that our people have. We can't sue them for the value of the deer. What we can do potentially is call the sheriff and get a misdemeanor violation on that person for the value of the lock that they cut. That's our only recourse at that point. So we're very concerned that unscrupulous people could use this to their own advantage to create a situation where they can take a very valuable piece of property without any compensation for the owner. Under Section 16, the GPS chip or tag option, most importantly, note that no technology currently exists for an implantable or otherwise GPS tag for cervids. It's not the same as what you would expect to see on a dog or a pet. Those type of technology don't work. When we saw this bill last year and again this year, we immediately went to work to do research, and we found that there was no technology that was existing today that would be transmissible to a cervidae. So this is not workable. And the other option would be the tag. So on a deer, you have what's called a panel tag in the ear, which contains a specific number for that deer, which is on record with the Board of Animal Health. And there's also a USDA tag. And the tag that would be required would have to be visible to the naked eye at 50 yards. Mr. Chair, with the information required on these tags, name, address, and phone number, it is virtually impossible to place that on a current tag the size that we are using. We would have to go to much larger tags. And in that case, in order to be visible at 50 yards by the naked eye, you're going to have an enormously large tag in order to be compliant with this section. Mr. Chair, this can cause irreparable damage to the ear of the deer and is totally impractical in daily actions around the farm. So, Mr. Chair, we're very concerned about these provisions. We find them to be specifically discriminatory against deer farmers. Please keep in mind that no other form of livestock is subjected to this type of statutory limitation. You don't have the ability to buy a deer license and shoot an escaped cow or other form of livestock. This is specifically discriminatory against cervid farmers. And we're very, very concerned and would like to ask that this type of legislation be removed from the bill if possible. Thank you, Mr. Chair, for your time.
We'll wait on the questions until we've got 2 more testifiers to go. So, Mr. Forrester.
Mr. Chair and members of the committee, my name is Jeff Forster with Minnesota Lakes and Rivers Advocates. We represent over 250 lake associations and about 6,000 individuals and anglers, resort owners, marina owners. And I want to express support for including language from House File 4254, Representative John Purcell's bill regarding recommendations for a watercraft operator's safety program, Section 68 of this bill. We believe this is a step in the right direction. Watercraft are evolving in both design and impact and are larger, more powerful, and can have more impact on our lakes and lake-based recreation. We agree with Colonel Smith's from the DNR observation at the first hearing of this bill when he noted that Minnesota has operators certification and training for every vehicle type except boats, and believe it is time to take a look at this. As our water bodies have become more crowded, I've seen less and less evidence that boaters follow or even know the basic boating safety rules, rights of way, and responsibilities for staying well clear of canoes, kayaks, sailboats, and other smaller or less maneuverable watercraft. Safety is paramount to everyone's enjoyment of our public waters, and the safe operation of watercraft will also reduce conflict among various user groups. By using science to develop some best management practices and education, and using well-established practices from trusted sources like the U.S. Coast Guard, the Minnesota DNR, and interested parties will be able to develop a boater's certification training that promotes public safety, protects aquatic environment, and increases enjoyment of all. We also wish to convey our support for the following LCCMR items. Section 55.1, freshwater sponges and AIS, engaging citizen scientists. Section 63.14, applying new tools and techniques against invasive carp. Section 64.1, testing effectiveness of aquatic invasive species removal methods. And 64.13, invasive rock snot on the North Shore streams. Thank you, and I'll stay on for if there's any questions.
Thank you. Colleen Sadisher, Research Coordinator, Department of Ecology, University of Minnesota.
Hello, Mr. Chair, members of the committee. I just want to thank you for choosing to include LCCMR recommended projects in 2020, and to thank you for attending to the full needs of our state in this time of pandemic. Thank you for recognizing that these projects not only deliver important information to the state, but they also spend money around the state and support people's jobs, including my own, 2 of my colleagues, and nearly 120 other full-time equivalent positions. We would rather be doing our jobs than looking at unemployment. I'm staff at the University of Minnesota and lead on the project called Improving Pollinator Conservation by Revealing Habitat Needs. Minnesota's 270 bee species are basically all under a stay-at-home order from hatching to adulthood every year, and yet people don't know where most of these bees live. My project proposes groundbreaking work to understand bee nesting habitat all around the state of Minnesota and to give this information to agencies and citizens so that it can be used to help ensure new pollinators emerge each spring. Thank you very much for the opportunity to testify.
Thank you. Could you state your name for the record?
Mr. Chair, my name is Colleen Sadisher.
Thank you. Representative Becker-Finn.
Thank you, Mr. Chair. And I know we're short on time, so I'll be brief. I just wanted the record to reflect that we did have a lengthy discussion about the exact same language regarding cervids last week, and would suggest that folks go back and take a listen to that for a full discussion. I don't think we need to rehash everything, but I do want our legislative record to reflect that there is a problem, with tagged deer, unrecovered, being in the wild, and hunters being in a situation where their licensed hunter is out in the field, and then they're the ones put on the spot by no fault of their own. And then, as stated last week, I think too that to point out that criminal laws still apply regardless of anything that we would do with this language, and that, as stated by the DNR last week, this is actually not that big of a change from what they currently do. And then on another note, on a totally different part of the bill, but did want to highlight how important it is that we support the Minnesota Zoo at this time. It's my understanding they're under incredible financial stress, and we're at risk of losing that resource in our state. And so I think anything we can do to support the zoo right now is going to be incredibly important for the future of our state, not just for sort of the benefit to folks who like to visit the zoo, but the research and all the other things that the zoo brings to our state. So just wanted to point out that is included, and I'm happy to see that in the amended language. Thank you.
Thank you. And Representative Green, before I go to you, I'd like to have Ms. Gothier directly answer Mr. Carnival's question on the landfill issues. And then, is that okay, Representative Green?
Yes, Mr. Chair, that's fine.
Ms. Gothier.
Thank you, Mr. Chairman. I'm actually going to turn it over to my colleague, Commissioner Kadelka, who has been doing the work with Mr. Carnival and his client.
Commissioner Kadelka. State your name for the record.
Thank you, Chair and committee members. For the record, my name is Kirk Kadelka. I'm Assistant Commissioner with the Minnesota Pollution Control Agency. I will just briefly talk about Section 60 of the bill, dealing with the ability of the agency to have environmental covenants in the solid waste program. These are already outlined in state law under Chapter 114E. State law does require, though, that for an agency to enter into an environmental covenant, it does need authorizing legislation in another section, another chapter of law. And we've done this for Superfund and a few years ago, the Petroleum Remediation Program. As Mr. Carnival has mentioned, we are working with the NWRA on this and have been trading language back and forth. But the intent of the language is for voluntary entrance into environmental covenants to make sure that protections put in place at a landfill, whether it's making sure a cap is not disturbed, or if there is a plume that's stable, wells, drinking water wells are not placed in them, that is known to the next land buyer and is enforceable by the agency. We have found that those notifications previously mentioned are not effective, and during times of transfer, they are not seen as what would be an environmental covenant on properties, and they have proven to be ineffective. And so that's why we're moving forward with this approach to address what is coming to Minnesota, a number of landfills either going to close or within their 20-year post-closure care, and want to make sure that we have adequate protections as these facilities move into the future. Thank you, Mr. Chair.
Representative Green.
Thank you, Mr. Chair. And just for the record, I wanted to clarify that in our last meeting, when we discussed a lot of these issues, we never really did come to answers, and there were no good conclusions. But the policies that are in this bill really have not been thought out well, in my opinion. And as far as the vandalism goes, when we went through the numbers last time, a good share of the deer that had escaped were contributed to vandalism, and many of those deer were then again recaptured. So that's something that we need to point out. And then just another comment, as far as the zoo is concerned, I understand that the zoo is having some problems with the closures in the state, but so are a whole lot of businesses. And so if we're going to be sticking money into state institutions, then we better start thinking about sticking some money into some of our private businesses as well. Thank you.
Representative Heinzman, and then Representative Lueck is on the phone. Go to Representative Heinzman.
Thank you, Mr. Chair, and hopefully DNR is still here and I could ask about the campground legislation that they were talking about that's in the bill, and maybe the commissioner could give me a little bit better idea what that does and how it may relate to campgrounds statewide being closed due to COVID, and if there is a plan maybe relative specific to this provision to deal with that issue.
Commissioner Meyer.
Mr. Chairman, members, the language in the bill is just a technical correction that reflects current accounting practices. It has nothing to do with private campgrounds whatsoever, just our revenue tracking and spending. The guidance that is still out there is public and private campgrounds are closed to recreational camping. There's two pieces of that. Is the governor's stay-at-home order encourages everybody to stay and recreate locally. And also, there are no large groups. It's a sanitation issue as well, since many of these, all of our facilities have commingled sanitation buildings, and we just cannot guarantee, nor can we keep them all disinfected if they were open at this point in time. So there are several factors that are applied to those decisions, and they're clearly identified within the DNR's outdoor recreation guidelines on our website and through MDH guidelines as well.
Follow up, Mr. Chair.
Representative Heinzman.
Thank you, Mr. Chair. No, I was specifically referring to the state campgrounds, and I'm trying to understand, if we have the campgrounds around the state, the private facilities potentially open under CDC and Department of Health guidelines for cleaning the facilities and trying to figure out what that might look like. And if that moves forward, I'm curious if DNR is prepared to follow those protocols and open up the state campgrounds as well.
Mr. Chairman.
Commissioner Meyer.
Members, the state is doing everything we can to open places safely as soon as possible. Once that is all clear, or we're able to move forward in a fashion that will allow the campgrounds to be open, we will be doing so as soon as possible. But currently, we are under the stay-at-home executive order through May 17th, and all public and private campgrounds for recreational camping are closed.
Representative Heinzman.
Thank you. I'd like to clarify that further. So I am wondering if, to answer the question, Commissioner, if a protocol is identified, a process for reopening private campgrounds, and for the public listening today, the public should know that if you have a permanent site with a fifth wheel or a camper on that location, those are open currently, as well as the showering and bathroom facilities. That's slated for opening in the next few days. So it is not completely unfeasible that the governor may look at other campground facilities that allow people to come in for a day with their own camper or unit of some kind. It's not infeasible to think that that could also open soon. And I'm just looking at this going, well, if those protocols that work for the private sector are in place and those facilities are open and they're following those systems to keep those facilities clean and usable, is DNR looking at making that available on state campgrounds as well?
Commissioner Meyer, and quickly, and then if you could provide to all committee members details about the policy relating to campgrounds.
Mr. Chairman, yes, and Representative Hyman, just really quickly, those private campgrounds do not have to open. They can open if they want to. I think that's an important consideration as well. If you go to the DNR website, right on the top banner, there's a link not only to MDH guidelines, but also to our outdoor recreation guidelines that clearly identify all of the criteria and protocols in place for all outdoor recreation, and the camping guidelines can be found there as well. I can send that link out to folks. We're in the process of updating that for when the new executive order goes into place Monday. and we can go from there, Mr. Chairman. And just briefly, we are doing everything we can to make sure that outdoor recreation opportunities are opened as soon as possible to people and in as safe as a possible manner. So once there are protocols in place that allow us to open things and the timing is right, we will be doing so as soon as we possibly can. But until then, with the stay-at-home order in place, campgrounds are closed until May 17th, if not longer.
Representative Lewick, we have 8 minutes left.
Thank you, Mr. Chair. First, I got two quick questions. First one is for MPCA. Do we have sufficient funding at the agency to continue to defend legal challenges on the permitting processes on a variety of fronts that on the finance side?
Ms. Gothier.
Thank you, Mr. Chairman. As I think there was in the governor's supplemental request an increase for legal reimbursement for legal fees for both the DNR and the PCA, and this was in regards to Polymet and the fact that we had to hire outside counsel because every major law firm in the state had a conflict of interest. So I have to confess, I'm not aware if that provision came through in this DE amendment today.
Ms. Gothier, so there are no general fund appropriations in the bill. And my understanding is the Senate, there are no general fund appropriations in the bill.
Right, so
that it is not there.
So that is something we will have to see what happens next week when the reforecast comes out and we get a better idea of the implications of the pandemic on our state. I can talk to our fiscal staff and find out what their plan is for navigating if those funds are not available.
Thank you. Yeah, thank you, Mr. Chair. That's a very serious oversight. But probably not going to resolve it here. The other question would be for the chair himself. I'm still really concerned about Article 2, Section 15 and 16. That is pure agriculture issues. Have you had direct conversations with the Ag Chair as to why this didn't go to the Ag Committee to deal with those particular areas?
Yes, I had direct conversation with Chair Poppy, and we were actually going to move this into my committee because it deals with outside the fence. So she did not want to see it.
Okay, as I understand you, you're saying that the Ag Chair said she specifically did not want to see that portion of the bill. I just want to make sure I understand what you said.
Yes.
Okay, I'm disappointed with that, obviously, too. And I for that, particularly that area, there's just no way I can support this this bill as it stands. Thank you.
Representative Fabian.
Thank you, Mr. Chair. And to that point with the CWD, is it really the intention of the author of that provision that someone through no fault of their own could be out many thousands of dollars because of a natural disaster or vandalism and one of their animals gets shot?
Representative Fabian, we have almost 450,000 deer hunters in the state of Minnesota who have been paying and changing dramatically the world in which they live in. CWD is a disease, the other epidemic that we've been dealing with. And we found this year, after the rulemaking, the special rulemaking, that deer farms had a lot more CWD than was anticipated. So we know that they can be a vector. And there's a huge public cost. There has been for many years, and there will continue to be a public cost for cleanup. So responsibility of maintaining the fence. Representative Fabian, you know, I grew up on a farm, and good fences make good neighbors. Maintaining that fence. We know there are examples when there are storms, etc. But we also know there are times when it's not. And need to keep the animals in the fence. As Representative Becker-Finn mentioned last time, these are an animal that is wild game in Minnesota and wild game that belongs to the public that has been affected by this disease. We did debate this last time. Most of the bill that's in front of us as amended today has been heard in committee already. Many of the components have passed through other committees or were in the governor's most recent budget bill. They are going to Ways and Means so we can continue the conversation. You'll see as an example today, we actually separated out the TCE ban and ran that separately. That may be possible for other components of this bill, but we need to get it to Ways and Means, and we need to get it to Ways and Means today. I did have a call with Senator Ingebrigtsen today. I think that's a good step to start that conversation. We have a few weeks left in session. As we know, and as we talked about compromise earlier today, not everything's going to get included, but there may be things and there may be things that change. So I would ask Representative Fabian, maybe one final comment. I know we're moving towards the end here. I know you're very concerned about this particular item, but I hope I've answered your question.
Well, thank you, Mr. Chair. I'll move on. I have a question for Ms. Gauthier with regard to the, just a follow-up on Representative Lewick's. How much money did MPCA, and if she said this, I apologize, how much money did MPCA spend in the previous year on the Polymet legal case?
Ms. Gauthier.
Thank you, Mr. Chairman. Thank you, Representative Fabian, for that question. I apologize I do not have that dollar amount at my fingertips, but I will get it in an email to the members of the committee ASAP.
And members of the committee, we're hoping that, Representative Fabian, that when we get the mini forecast next week, we will have a better idea on general fund, and this bill would be there. We know that we're probably going to get a supplemental budget from the governor. So I know it's a priority for the agencies, but we don't have that right now. One final thing, Representative Fabian.
Thank you, Mr. Chair. And this goes to the PFAS study that MPCA is doing. The money for that. What's going to be the target of the study? I'm curious. That I have one real quick thing to add to that, if I could.
Why don't you just add it right now?
Okay, so my question is we're doing a PFAS study. We have the PFAS language in there from the Claflin bill about the food packaging and so forth. And we're banning all that stuff. And I think that some of it is really quite unneeded because it talks about straps and buckles and pallets and all that stuff. Why would we proceed with the study and then do the ban at the same time when we don't have the information that MPCA needs for the study, and how much money do they need for that?
Ms. Gauthier.
Thank you, Mr. Chairman. The request of funding for the study from LCCMR was 1.4 million. That study is kind of an applied research project looking for strategies that can be used to manage PFAS in land applied biosolids. So we're trying to develop strategies that will help businesses, communities, municipalities manage PFAS in biosolids. There are a couple other points of research, but it is research that will advance our knowledge. We do not need more research. We are not doing research about whether or not PFAS exists elsewhere or is out there or what form it's in. We already have a lot of that data. What we're trying to study here is something that hasn't been studied yet anywhere, and that is kind of how do these PFAS move in the groundwater and in the soil.
I would renew my motion that House File 4554, is that correct? Would be as amended, be sent to the Ways and Means Committee. Clerk will take the roll.
Hanson.
Aye.
Claflin.
Aye.
Fabian.
No.
Backer. Backer. Becker-Finn.
Yes.
Eklund.
Yes.
Fisher.
Yes.
Green,
No.
Heinzman,
No.
Lee,
Yes.
Lewick,
No.
Morrison,
Yes.
Nelson,
No.
Purcell,
Purcell, aye.
Purcell, aye. Sandell,
Aye.
Sundin,
Yeah, no, these don't, the minutes going last into 16, 17-year-old.
Sundin,
Aye.
Tice,
No.
Wagenius,
Aye.
Backer, Representative Backer, the current count is 11 ayes, 6 nays.
The motion is adopted.
Yeah, no.
Oh, Representative Backer was voting while I called that. So, Mr. Schwartzweiler, what's the final count
11 ayes, 7 nays.
with Representative Backer?
Correct.
Motion is adopted.